City Hall's hidden landmine. The legal trap turning multi-million-dollar developments into financial quicksand. Think a city-issued permit protects your investment? Think again. There is a brutal reality in municipal law that is catching investors completely off guard. If a city cuts corners to pass an ordinance, your good faith armor completely evaporates. Imagine a developer, acting in total good faith, pours millions into a project based on a newly passed city ordinance. They have the permits, the equipment, and the green light. But behind closed doors, the city administration violated the Constitution or state law by slapping a fake emergency clause on the ordinance just to rush it through, bypass public notice, and strip citizens of their right to vote on it. The developer has no idea the city broke the rules. But in court, ignorance isn't bliss, it's catastrophic. Here is exactly how this legal trap snaps shut on unsuspecting projects. 1. The void from the beginning rule. Under established constitutional law, if an ordinance is passed in violation of constitutional mandates, it is deemed void ab initio, void from the beginning. In the eyes of a judge, that law never legally existed. Because a city cannot grant valid development rights using a law that doesn't exist, your building permits and zoning variances instantly turn into useless scraps of paper. 2. The good faith shield instantly melts. Developers often rely on vested rights. The idea that because they spent money relying on the city's approval, they should be protected. But courts have made it clear. A developer's financial reliance cannot override the public's constitutional rights. If the city didn't have the lawful authority to pass the rule, they didn't have the authority to give you a permit. Period. 3. Developers become costly collateral damage. When local citizen groups or advocates file a lawsuit and win, the court doesn't bail the developer out. Immediate injunctions can freeze construction in its tracks. Heavy equipment sits idle while interest on construction loans piles up. In extreme cases, courts can order the removal of structures built under the void permit at the developer's sole expense. The takeaway for investors and advocates: due diligence is no longer just about environmental checks and blueprints. In today's climate, you have to audit the legality of City Hall's legislative process itself. If a city administration rushes a controversial district or ordinance through using a shaky emergency clause, the developer is the one left holding the multimillion-dollar bag. What's your take? Should a private developer bear the total financial ruin when a city administration is the one that broke the law? Drop your thoughts in the comments below.